Good morning, this is your Kelso Report for Thursday, September 13th, and I'm your host, Clark Kelso. We look at two cases this morning. The first involving a district court's authority to compel certain government lawyers to attend settlement conferences. And the second involving the constitutionality of a portion of Jessica's law as applied to parolees in San Diego County. Let's begin with a case involving authority to order attorneys to attend settlement conferences. The federal government, as a litigant in federal courts, is given some pretty special treatment procedurally because the government is such a frequent litigant in the courts. In the United States v. District Court for the Northern Mariana Islands, the Ninth Circuit had to review an order by the district court in a number of cases which directed the government to be represented at initial court settlement conferences by a representative with full authority to settle a civil tax refund lawsuit. From the district court's perspective, not having someone present with full authority to settle interferes with settlement talks because you don't have a person who can cut the deal. You're always having to call back to Washington, and there are delays in settlement. Well, the problem with the federal government is the Department of Justice has internal rules that limit settlement authority to certain individuals within DOJ, typically back in Washington. And the higher the dollar amounts involved in the case, the higher the official within DOJ. As a practical matter, then, DOJ simply could not send someone with full settlement authority to every settlement conference held around the country without altering their internal rules designating who has authority to settle. Out of respect for those rules and the practicality of the situation, the Ninth Circuit joined other federal appellate courts which have held that, while the district court has authority to order parties to participate in mandatory settlement conferences, including government attorneys, the exercise of that authority is subject to review for abuse of discretion. And, based on the facts before the court, the Ninth Circuit concluded the district court had abused its discretion by ordering a government representative with full settlement authority to appear at an initial settlement conference in a routine civil tax refund lawsuit. The court indicated that, maybe if it wasn't the initial settlement conference, maybe if it was somewhat further down the line, maybe if it's not a routine case but a really big case, maybe you can do it then. But as a general matter, the district court shouldn't try to force DOJ and their officials to fly around the country for settlement conferences. Next, we have a case involving Jessica's law. California's voters have become accustomed to enacting sometimes rather extreme measures through the voter initiative process. And the voters get fed up with inaction in Sacramento, and they take matters into their own hands in the initiative process. Well, a problem with the initiative process is that there's no real opportunity for proponents and opponents to reach compromises that might soften the rough edges of the proponent's initial proposal. And the result in many voter initiatives is to enact a provision that pushes right up to or exceeds constitutional boundaries. According to the 4th District in In re Taylor, that is what happened with a provision in Jessica's law, which was adopted by the voters in 2006. Among other things, the proposition enacted revisions to the penal code that made it illegal for registered sex offenders to reside within 2,000 feet of any public or private school or park where children regularly gather. Subsequently, the CDCR adopted a policy to enforce the residency restriction as a parole condition for registered sex offenders. The question in re Taylor was whether the residency restriction could constitutionally be applied to registered sex offenders on parole in San Diego County. The case had made its way up to the California Supreme Court, which in 2010 remanded so the Superior Court can make a factual determination whether the restriction when enforced as a statutory parole condition, constituted an unreasonable parole condition to the extent that it infringed upon parolees' fundamental rights of travel. Well, the evidence presented to the Superior Court overwhelmingly established that the 2,000-foot restriction virtually foreclosed registered sex offenders from any affordable housing anywhere within San Diego County. Becoming homeless and sleeping in alleys was the remaining option. Given that record, the 4th District had no trouble at all affirming an injunction barring enforcement of Jessica's Law in the parole context in San Diego County. We'll see what the Supreme Court does with this decision. It had remanded the case before. Oftentimes when it does a remand of this sort, it'll take the case up again to see whether it agrees with what the Superior Court and Court of Appeal have done during the remand. Well, that's it for today's Kelso Report. Have a great day in the law.